Court of Appeals, Division 1 is now in session.
Please be seated. This is the time schedule for our oral argument in Hyatt and MCA Financial Group v. Shaw, our case number 1CACV140441. Each side has been allocated 20 minutes for oral argument. There's a clock on the podium. The clock shows how much time you have, including your rebuttal time. So within the 20 minutes for the appellant is your rebuttal time. If it shows 5 minutes left, that includes your rebuttal time. So you'll need to manage your own time. To assist you, you should be aware that we have read the briefs, we have looked at pertinent portions of the record and authorities, and we have conferenced this matter. So there's not really necessary to go into a lot of the detailed facts unless you feel otherwise. Each side has 20 minutes. If you don't, there's no requirement that you use it all. If you're done speaking, have nothing else to add, we have no questions, feel free to sit down. You should also be aware that we are recording these proceedings, both audio and video recording. So when you approach the podium, please clearly state your name and who you're representing. And in a couple of weeks, I believe, the video appears on YouTube. You can actually search for it on YouTube and watch it. So with that, counsel for the appellant.
May it please the court, I'm Eric Pelletier and I represent the appellant Hitel Shah. The issue in this case is whether or not the trial court abused its discretion in granting the receiver's petition for further instructions, which sought to authorize a payment to Dr. Carl Hyatt in the amount of $473,364, where Dr. Hyatt didn't timely file a proof of claim as required by the trial court's claims bar order. We believe it was an abuse of discretion because the claims bar order was clear, and the trial court, instead of finding that Dr. Hyatt had filed his proof of claim in an untimely fashion, it found that the receivership certificate that Dr. Hyatt had was in and of itself a proof of claim, or alternatively, that he didn't need to file a proof of claim. Also, we believe that the trial court should have made some investigation into the question or the issue of why Dr. Hyatt didn't file in a timely manner.
As to the last point, Dr. Hyatt attached an affidavit to one of his pleadings in the Superior Court addressing what had happened here and why he didn't meet the deadline. Dr. Shaw did not attach anything. You didn't ask for an evidentiary hearing. So why should the trial court have done anything based on that record of the absence thereof?
I'm sorry to interrupt,
No, please
Judge
go
Norris.
ahead.
The trial court, in the trial court, the receiver's counsel had the receiver present, or the receiver's representative present, and he had indicated that there was a dispute as to the reasons as to why Dr. Hyatt had, what had happened that led to Dr. Hyatt's untimely filing. He said, Dr. Hyatt had said that he had contacted the receiver's office and made inquiry as to whether or not he should file it, and was told he didn't need to file this proof of claim. The receiver made, I guess, what could be considered a proffer at the trial court level, that the contrary was true. After the claims bar date had passed, Dr. Hyatt had made this call and was told nothing. He was told, we're not going to tell you what to do. Do it if you think it's necessary. So that in of itself.
But at that point, with that conflict, did your client request an evidentiary hearing?
It did not,
No,
Your Honor.
okay.
And we concede that. But part of the issue is that there's such a sort of a vacuum as to what happens in cases, receivership cases like this. There's not really a standard to deal with, and that's why we brought up this issue of the excusable neglect standard. There's not really a standard to deal with what happens in situations like this, where there's a belated claim and it falls in this gray area. So if our point really is, if the court is not going to hold firm to the claims bar date that the trial court established, okay, and by the way, the claims bar date was set by Judge Anderson, And a subsequent judge basically allowed Dr. Hyatt to sidestep that. So if the court is not going to hold firm to that, then our position is have some standards so that these issues can be addressed at the trial court, because otherwise, especially if there's a reported opinion in this matter that allows something like this to go on, it'll wreak havoc on the receivership process, because someone could always point to the Hyatt situation and say, look what happened there. Dr. Hyatt was able to sidestep the claims bar date, but he was able to have his claim paid. So,
Of course, we don't really need to address that issue if we agree with the first reason given by the Superior Court on why Dr. Hyatt didn't even have to file a claim, because the receivership certificate really was his claim and the court had already approved it.
well, in a manner of speaking, you might be right, but we disagree, simply because what happens if Dr. Hyatt had never filed his proof of claim? We know what the receiver said, because at the trial court during the proceedings on this issue, the receiver said if Dr. Hyatt had filed a year later or 2 years later, he wouldn't have accepted the claim, and he wouldn't have moved the court to allow the claim to be paid. So, and that's at page 10 in the transcript. So, it's a sticky widget, okay? There's this receivership certificate, but then we have the receiver who's really not authorized to accept it based on the claims bar order, because the claims bar order states at Section D, any creditor, interest holder, or party in interest with claims as described above who fails to timely submit a claim, a completed and signed claim form on or before the bar date, shall be prohibited from asserting such claim or submitting a completed claim form with respect thereof in any manner against the receivership estate. So right there, Dr. Hyatt should have been out the door. But we know that Dr. Hyatt felt that the proof of claim process was important because he submitted a proof of claim. So in a way, his argument undercuts the trial court's finding that says he didn't need to file a proof of claim. Dr. Hyatt almost concedes that he needed to file a proof of claim.
Counsel, let me ask you a question. I want to get back to a comment you made a minute ago. You said there's not a lot of guidance in this area, but then you also said that if this case were a published case, it would wreak havoc because of the facts of the case. I'm not sure I was following you. Are you saying it would have been more helpful to your client to know what to do if there had been a published case that stated the court has discretion, or excuse me, the receiver has discretion, and here are some factors to consider? Or are you saying this bad facts make bad law, and this is the wrong case to do that?
Well, that's a difficult question to answer. In terms of the briefing at the appellate level, it would have been easier to find if there were guidance, okay? But in terms of what we were supposed to do below, I think our position is we knew what we were supposed to do below, and we followed the steps and did what we needed to do. And in terms of raising an objection below, there really wasn't clear guidance other than the claim, and we went to the Seventh Circuit for the Lakeshore Asset Management case for this standard, but there wasn't really clear guidance, and so we just pointed to the claims bar order and the notice, the claims bar notice, and the proof of claim itself for guidance as to what should have happened. So again, the claims bar order says you couldn't assert claims, you can't participate in the above captioned receivership estate with any plan of liquidation, and you're barred from receiving any distribution. And it's black and white. You had to have filed your claim by January 2nd. It wasn't discretionary. The claims bar notice makes it very clear that that was the bright line date. You had to file your proof of claim.
But doesn't that, and this is the issue I find the most difficult in the case, what you're now just discussing. But given that the receiver was a party to the settlement agreement, and the court had approved that, and had authorized the receiver to issue the certificate, I'm having a hard time distinguishing why does that not constitute why does that not already commit the receiver to honor the claim?
Well, Your Honor, I can only point to the claims bar notice, the proof of claim, and the claims bar order, which doesn't create an exception for receivership. In this case, Dr. Shaw was a joint interest holder in receivership certificates 1, 3, and 4. He filed his claims on time, and he also filed a separate lien claim based on this movie tax credit that he had a lien against on time. There was no exception in any of the orders. And so he followed the requirements, and Dr. Hyatt should have, because if the order created some exception for the receivership certificate holders, it would have saved my client money. He wouldn't have had to submit his claim on the certificates 1, 3, and 4. So, but that exception just didn't exist. And the irony here is the receiver wanted this process. The court granted the motion at the receiver's request that put this process into place. The receiver served this on everyone, served it on the Hyatts. They admit they got the notice and so on and so forth, and they didn't file their proof of claim on time. Ultimately, they did file it, and it's an acknowledgement that they had to file it, we think. So, you know, and I made the point that the receiver had conceded that if the filing was a year late, the receiver probably wouldn't have allowed the claim.
You know, I looked at that page of the transcript, and it's at page 9 of the transcript, and I think I read it a little differently than you do. What I read the counsel for the receiver saying is it might be different if the Hyatts had filed a year late or 2 years late and there was some sort of reliance that the parties and the receiver had. And that makes some sense to me, that if there's some type of reliance, it almost rises a level of some type of estoppel. So I read that Q&A a little bit differently than you do.
Well, Your Honor, I guess the way that evolves is, assuming your interpretation is right, what has happened is, you know, granted, we filed the objection, we filed the appeal, but it's created this incredible delay, and it's not as though we don't have a valid basis for objecting, because we have the claims bar order that wasn't followed in this case. So, you know, it's our position that there is prejudice, and we relied on the orders to do what we were supposed to do. It's not the same type of reliance that may have been what the receiver was talking about in that context, but, you know, it's very clear we did what we were supposed to do. And, you know, the receiver in his brief points out that the claims bar, he cites Ralph Clark, a law journal article by Ralph Clark from the 1920s, that a claims bar date is not the same as a statute of limitations. But I just want to point out that in that same article at page 495, Professor Clark goes on to say the courts are liberal in extending time to allow claimants who have had no notice or opportunity to come in and prove their claim. If a party, however, has been guilty of laches, the time will not be extended, nor will his claim be allowed to be filed. And so in our brief, we stated one of the maxims, equity aids the vigilant. Here, this is an equitable context, and Dr. Hyatt simply wasn't vigilant. The requirements of the claims bar order were very clear, and he didn't follow them. It doesn't matter if he didn't have an attorney at the time. That's his choosing. So, you know, in short, we think the trial court at a minimum should have adopted some standard to lend guidance to other people in this situation down the road, or sought some standard. And, you know, the commodities future trading versus Lakeshore Asset Management case that we cite, Judge Posner from the Seventh Circuit, he points out that a court will typically take into account all the relevant circumstances surrounding the party's omission, including the danger of prejudice to the receivership estate, the length of the delay, its potential impact on proceedings, the reason for the delay, and here there really wasn't one, although that was one of the disputed factors. And granted, each side has their own side of the story. Whether it was within the reasonable control of the late party, and whether they acted in good faith. Now, we just want to point out, if there's 2,000 creditors in this case, $54 million in claims, this is the only late claim that we know about. And so it certainly was in his reasonable control, and the delay was 20 days. It wasn't 2 years, but the impact it's had has been great, because here we are.
So you're arguing that if we were going to issue a decision setting forth the standard for the courts to use, we should follow Lakeshore? Basically a totality of the circumstances? It
is. It seems to be the most applicable test. Certainly, if we were trying to advantage ourselves more, we would have sought a more stringent standard, like good cause. But that's a lower standard, and it seems to be the one that the federal courts, or some federal courts, have used in this context. And I'm going to wrap up shortly, unless the court has any other questions of me. But, the fact is, the receiver created the process. The receiver didn't follow the process when it came to the Hyatts. The court, ordered the process, didn't follow the process. And it wasn't as if there was a reconsideration motion put before Judge Anderson, who was the judge that signed the claims bar order. It was a subsequent judge who basically changed the process for one party alone out of 2,000 plus. So That's really our position. But in anticipation of what Mr. Conant may be arguing on behalf of Dr. Hyatt, he's made this equitable estoppel argument, saying that there were these earlier orders that, basically put in place the receivership certificates. We don't dispute that they're valid and that those orders exist. We certainly didn't oppose them. We actually benefited from them because we have the receivership certificates to our credit. But we're talking about the subsequent order, the claims bar order that we followed, that Dr. Hyatt didn't object to, that Dr. Hyatt didn't oppose at the motions stage, and now Dr. Hyatt doesn't want to follow it. So if anybody should be stopped, we believe it should be Dr. Hyatt. So for these reasons, we believe that the trial court's orders should be reversed and Dr. Hyatt should be, the trial court's finding that Dr. Hyatt's receivership certificate is a proof of claim, or that he didn't need to file a proof of claim, should be reversed, or alternatively, he should be required to go back below and show some kind of excusable neglect. Thank you.
Counsel, I had a question.
Yeah.
I noticed that Dr. Hyatt requested attorney's fees in his answering brief as a matter arising out of contract under our statute 12-34101A. And in your reply brief, I don't think you said anything about that.
We didn't, but
do you concede that this matter arises out of contract?
we don't concede that, Your Honor. We believe that this is, it's an equitable proceeding, so we believe it's not, it doesn't fit within that statute, and that we shouldn't be responsible for any attorney's fees that Dr. Hyatt incurs in the event he succeeds on this appeal or prevails on this appeal.
Even though his defense base is based on the settlement agreement and the certificates?
Well, but the context of this case is whether or not he met the claims bar date order, and he didn't. That's the reason why we're here, okay? So it's a different issue, and that's the issue before the court. Did he meet the requirements of the claims bar order? He did not. So, thank you.
Good morning, Your Honors. My name is Ben Reeves. I'm with Snell & Wilmer. I'm here on behalf of the receiver, and may it please the court. I think, Your Honors, the briefing in this case does a pretty good job of setting forth everybody's position. We think, as the receiver, that Dr. Hyatt should be paid, but obviously we'll do whatever the court orders us to do. I'll be very brief in my presentation today. I just have a few things I think that will help frame the record, if you will. First, to put this appeal in context, just to take a step back, this is a receivership over a video gaming company. It was going to develop a game for the Stargate franchise. The receiver received over $50 million in claims. He did his investigation with the full knowledge and support of the court, of the creditors. He looked at the coding and the software to see if that could be salvaged. He looked at potential litigation. He looked at selling the business, but it all turned out to be cost prohibitive. Dr. Shah and Dr. Hyatt both funded some of that investigation and were issued receiver certificates with approval of the court and full knowledge of everyone. At the time those were issued, everyone was hopeful that there would be another source of recovery, but unfortunately that was not the case. When the receiver determined that it was going to be cost prohibitive, he proposed the claims submission process, which the trial court approved. And at that time, there was just enough money to pay back the expenses of the receivership estate, which obviously take priority over general and secured creditors. No one in that process argued that the receiver should continue to do his investigation and try to find out another source of recovery. The only dispute, and the dispute that here today, is who the receiver should pay. The receiver proposed to pay the administrative claimants, again, because those take priority. Dr. Shah objected solely because Dr. Hyatt filed a late proof of claim. Our brief sets forth our position pretty good. Just to reiterate.
Mr. Reeves,
yes.
Excuse me a second. I want to go back for a moment. I want to make sure I understood what you said. Does the receiver take the position that Dr. Hyatt's claim is an administrative part of the administrative cost incurred by the receiver?
Yes, Your Honor. All four of the receivership certificates will be paid, and that's what the receiver proposed to pay. As
part of its administrative expenses.
As the expenses of the receivership estate,
Right.
yes. He incurred that debt to help fund the investigation and costs, and the court ordered him to pay that money back. He borrowed it, and he's going to pay it back.
So what I'm getting at is this. Let's say hypothetically that Dr. Hyatt had actually been a separate creditor. Maybe he had provided certain medical services to the companies. I don't know what he could, but let's just assume for that. So he's completely unrelated to the administration of this receivership, just a standard third-party creditor. If he had then submitted his claim 20-some days late, would the bar order apply here to bar that claim, his claim?
I believe so. I think the receiver and the court would still have discretion to allow it based on, I think the totality of the circumstances is the
But
appropriate
at least the
analysis.
first issue or the first reason given by the trial judge that you've argued is that, well, it wouldn't be something that had effectively had already been approved.
Right. That would have been somebody, a stranger to the case, coming in and saying, hey, I'm entitled to be paid. And the receiver at that point would have to look at it and say, well, did you receive notice? Didn't you? Is your claim valid? Isn't
Right,
it?
right, okay.
Is it? If he would use his discretion to make that determination and make a recommendation to the court, and it would be up to the court to decide whether or not to allow it, I think. And that goes to my next point, I think, which the purpose of this receivership claims process is to put the receiver on notice of the claims that are out there. And here, Dr. Shah knew about the claim, that's not disputed. The receiver knew about the claim, that's not disputed. The court knew about the claim, that's not disputed. So I think the reason behind the claims process has been satisfied because everybody knew about it. We think Dr. Shah's argument really just elevates form over substance, and the receivership court as a court of equity, that's the exact opposite of what courts of equity do. The only legal issue I'll touch on, I think, is in Dr. Shah's reply brief, he cites to Corpus Juris Secundum 75 CJS 274, which is titled Presentation of Late Claims. And I think this really proves our point. And I'll just read, it's pretty brief from the document. In general, where an order is given for the publication of a notice of a limitation of the time to file claims, and such notice is duly published, claims not filed within the time specified in the notice are precluded in that proceeding from sharing in the assets. So that would seem to support his argument, but it goes on. However, such orders are not given the effect of inflexible rules independently of legitimate purpose. Accordingly, this result is held to follow only where there has been, in the meantime, a final distribution of the funds in the hands of the receiver based on claims proved. And the case that CJS relies on is this Bankers Trust v. Florida East Coast Railroad Company, and that's a railroad receivership out of the District of Florida. And in that case, it was a widow who submitted a claim on behalf of a railroad employee who ceased, and she submitted it late. And the court held in that case, those objecting to the petition, the widow's claim, also make the point that petitioner's claim was not filed within the time fixed by the court's former orders herein relating to claims generally, and therefore the claim is barred. The object of requiring the filing claims within the stated period is to give the receivers timely notice of the existence thereof. As counsel who specifically consented to the entry of the judgment in favor of the widow were also counsel for the receivers, there is ample notice of its existence. There is no substantial reason for requiring further proof of such claim. And I think that pretty much sums it up here. The receiver knew about the claim. The court knew about the claim. The purpose of the claims process is to provide the receiver notice of the claims. That obviously happened here. Just to touch on a few things raised in oral argument, a couple thoughts came to mind. As to whether or not to remand, and there's a disputed issue of fact, I think good cause the dispute as framed by appellant is whether or not Dr. Shah called the receiver's office before the claims bar date or after and received someone telling him, don't worry about filing a claim. I think if that happened or not, either way, the court still could have found that to allow Dr. Hyatt's claim for the reason that, one, the receivership certificate is proof enough. Second, so he was entitled to rely on that. So if he didn't call, I think he would have been justified in relying and thinking and believing that the claim itself would have been satisfactory. Second, if it did happen, which the receiver thinks it didn't, but if it did happen, then I think the receiver telling him, "Don't worry about it," that'd probably be substantial cause as well. As to the claims order, the language read during presentation, it says that Hyatt would be prohibited from asserting the claim, not the receiver. Here, really the receiver saying, "Hey, I have this obligation to pay and I want to pay it back." So I think you can get around the language in the claims order based on that. And I think, Your Honor, Judge Norris, I think you hit the issue right on the head with, had it been a year late and there had been prejudice, then I think the receiver would have taken a different position here. But here it's 20 days late. Everybody knew about it. Lashes, as he argued, I think requires extreme prejudice and extreme delay. I don't think that happened here. So unless the court has any further questions. Thank you, Your Honor.
May it please the court, my name is Paul Conant, and I represent Dr. Hyatt, who's also present in the courtroom today. One of the things that we addressed in a large scope fashion in our response brief was the equitable nature of the proceedings. But there's a particular, in preparing for the oral argument, there's a particular passage that I noticed in, it's on page 2 of Dr. Shah's opening brief. And it's, I think, an attempt to make an equitable argument. It's not in the facts section, it's in the statement of the case section. And it's at the top of page 2, and he says, because the receivership estate had finite assets, payment of the Hyatt's claim would deplete the estate and leave nothing to pay Dr. Shah, who was the next highest priority creditor of the receivership estate. I believe that is not correct based on the record that's in front of you, and I want to point you to the two portions of the appendix that I believe do set the record straight on that issue. Apley's appendix at page 25 appears as a landscape-style chart that lists the 4 receivership certificates, and receivership certificate number 1 was issued and approved by Judge Burke. Remember, we have 5 different judges on this case because it's a consolidated case and it spans many years through judicial rotations in the trial court. So receivership certificate number 1, approved by Judge Burke, goes to DASH. That's the acronym. It's D'Alembert, Roberts, and Shaw. Shaw is part of that. So that is a $563,172.05 receivership certificate that, as part of the receiver's proposal for resolution to the trial court at the time, as Judge Gama, would be paid to Dr. Shah's group, if you will. Receivership certificate number 2 is on that page. It's appendix page 25. Appellee's appendix page 25 would go to Dr. Hyatt in the approximate amount of $642,000. So that's including the interest. So it is not correct to our way of thinking that somehow the trial court's decision to honor the receivership certificate that had been approved by a previous judge somehow creates an inequitable circumstance for Dr. Shah.
But my understanding is Dr. Shah had other certificates.
He has other certificates.
Those didn't get paid.
3 and 4, I believe, are scheduled to be paid on that exact same list. Okay.
Right, but at least my understanding was we wouldn't be here today if Dr. Shah's claims were fully paid.
Well, I don't think, because of the appeal, I don't think any of the claims have been.
I understand that, but I mean, let me try to rephrase this. Are you saying that the assets are sufficient to pay all of Dr. Shah's claims?
I think the claims that are memorialized by a receivership certificate, yes. I believe he probably has unsecured claims, as do all of the investors who invested money and lost money. Dr. Hyatt would have unsecured claims as an investor. These other claims that are secured by a receivership certificate were monies that were used to save the game, save the business, and so forth. So I think as to those claims, my understanding is that all of those save the business claims would be paid. It's the unsecured claims that all the investors are
Including Dr. Shaw.
He would be one of them.
So, okay.
Yeah. So, but when he says these the next highest priority, I don't understand that language to mean, hey, I'm worried about my unsecured.
But you're not arguing that he was not prejudiced because the Hyatt claim was paid. Because if Hyatt claim wasn't paid, there'd be more assets to pay other claims.
Yeah, in the big picture, yes, the $50-some million worth of claims. If Dr. Hyatt wasn't getting the $600,000, that $600,000 would be pieced and parted out to all of the many people who are disappointed by their investment. Yes, so that's one point in the record, and the other point in the record is the contract, the settlement agreement, which provides, and I'll give you the appendix citation here. It's page 44 of the appendix. That's an excerpt of this single-space, 11-page, heavily negotiated settlement agreement, and it's paragraph 1A that states that the obligations, this is the section dealing with the obligations, receivership certificate 1 going to Shaw, receivership certificate 2 going to Hyatt. It says that these obligations shall be secured by certain lien rights equivalent to a receiver's certificate granting lien rights in the most senior position legally possible. Okay, so that's what Judge Burke approves. I understand the case goes on, and we have Judge Anderson enter the case. And at that point in time, the receiver is trying to figure out how to save the business, if you will, say it in short fashion like that. The receiver reports back. These efforts are essentially going to be for naught. We have the tax credit. Let's divvy up the tax credit. I'm sort of summarizing what was going on during that time. That's during Judge Anderson's, when Judge Anderson was the trial court judge. And Judge Anderson says, okay, fine, I think I understand what's going on. Let's have a claims bar process so that if anybody has a claim out there, then they'll submit it. The order is what Dr. Shaw focuses on in his paper. The notice is what we focus on in our paper, because remember, the notice says your claim may be barred. It uses the term may, it doesn't say shall be barred. So what goes out to Dr. Hyatt uses the term may, and we cited that in our response brief where you can find that in the record. I think it's record ROA 251 at page 3. So Hyatt calls in his declaration or his affidavit is put in the record, belt and suspenders approach. Do I need to do anything? He walks away from that conversation with the receiver with the understanding that he stated in the affidavit. He does, belt and suspenders, put in the proof of claim. Even if the receiver had not proposed that Dr. Hyatt's claim should be paid on the receivership certificate number 2, this receivership certificate that was supposed to have the most senior lien position possible on the receivership estate per Judge Burke's order, even if the receiver had said, no, we don't want to pay that, I think, of course that didn't happen, but I think that Dr. Hyatt could have come in and said, no, I have a prior court order saying that I have a lien that's in the highest position possible. I don't see any conflict with the Lakeshore case because it's a totality of the circumstances argument. I don't see a paucity of legal authority in this situation because this is an equitable receivership. In other words, it's not arising because of a clause in a deed of trust that says if there's a default on this development project, then we can have a receiver appointed to operate it pending the foreclosure. That would be like a contractual receivership. This is an equity receivership where the court is exercising equitable powers. There is a huge body of law on the court's equitable powers. So in this case, in this courtroom today, we've had arguments about estoppel one way or another, latches one way or another. I don't think there is a need to attempt to refine things for judges or lawyers anymore. It should be clear from the existing law that the trial court, the person in Judge Gama's position, even if there are 4 judges that came before, has the ability, has the right to do equity at the time that the receivership termination motion is filed under Rule 66A. I don't have anything else unless you have questions for me.
Okay, thank you.
Eric Pelletier here on behalf of Hitel Shah, the appellant, once again. I'm just very briefly to the court. I just want to clarify the thing that Mr. Conant brought up about whether or not we were secured or not, and whether we were secured or unsecured creditor with respect to our movie tax credit lien claim. It's a lien claim. There's a UCC filed. I think that's probably in the record with respect to that lien. We are a secured creditor. We're just not the super priority creditor with respect to that claim that Dr. Hyatt is in this context, and Dr. Shah is with receiver certificates 1, 3, and 4. So we are not an unsecured creditor in that context. I just wanted to clarify that because I think that Mr. Conant, I take issue with the way he articulated that matter. Now, just and briefly, Judge Kessler, you asked about the issue of these contract attorneys' fees. Just to very pithily put it in a simple way, we don't dispute that there's an underlying settlement agreement. Our dispute is that we dispute that they didn't file the claim properly, and that's the crux, that's the gravamen of this fight. Okay.
Isn't, in part, Dr. Hyatt's defense to that grounded squarely in the settlement agreement that reads, in part, upon the official approval, Cheyenne Mountain entities shall be indebted to the parties, which included the receiver, to this agreement. And so that one of the arguments here is that, look, I did not have to file a claim because the parties had already agreed that the Cheyenne Mountain entities would be indebtedness. They had quantified the amount of the indebtedness, and the court had, in fact, approved it. So there was no reason why they had to pursue what one could argue a needless act. So that's their defense, and it's grounded right on that settlement agreement.
Our response to that is simple. Again, we don't think they get their contract attorney's damages because they failed to take an action. But in terms of whether or not that settlement agreement is in enough of itself sufficient, look at it differently. I think that there's a simple way to look at it, and it is if you have a contract and you modify it by a subsequent contract, the subsequent contract governs. If you have a court order that appears to have been modified by a subsequent court order which says everybody has to file a proof of claim, that's the one that governs. And I think that's the response to your question, Judge Norris, because it's not that he didn't have to file. The claims bar order said Dr. Hyatt and everyone else in the world that had a claim had to file if they wanted to have their claim processed.
Did all then, let me ask you this, did other administrative debtors of the receiver also have to comply with the bar order and file their claims?
I think everyone had to comply with the bar order.
The receiver entered into an agreement with, let's say, for hypothetical Staples, to buy paper and computers so he could do his job for this estate. Did Staples have to file a claim even though Staples was doing business directly with the receiver?
I don't think the claims bar order is ambiguous in any way. I think Staples would have. And just my understanding, and I'm not going to sort of force this on the court, but I'm pretty certain that the only real administrative claimants that we know of in this case were Attorney McGill, who's at page 25 of the appellee's appendix, Dave Roberts, Hitel Shah, and Samuel Dallenbert, and Carl Hyatt, and Mrs. Hyatt. They're the ones that are listed there as administrative claims. So everyone except for Hyatt filed in a timely manner. So I think the facts answer the question, too. So with that, Your Honors, we appreciate you hearing us today, and we would urge reversal of the trial court's order. Unless there are any other questions, I'll sit down.
No,
Thank you.
thank you. 1 second, though. Susan, did they sign in?
Yes.
Okay, good. Okay, thank both counsel for your briefs and your oral argument. We'll take this matter under advisement and issue a written decision in due course. With that, we stand adjourned.